A car accident can turn your life upside down. Right off the bat, there is so much to deal with if you're involved in a car accident. There's your medical bills, there's your property damage. If you're out of work, you want to be compensated for your lost wages. And even if you aren't injured, a car accident can be overwhelming. However, without an injury, most people do not need to hire an attorney. Most people don't even realize that it costs nothing to hire a personal injury attorney. The reason behind this is to allow everyone the opportunity to be able to pursue cases against the big companies and the insurance companies that cause them injuries and that have the money and the ability to pay, but the average person does not have the ability to fight them. So personal injury attorneys will only get paid if there is a recovery. My name is Phil Rizzuto, and I've been representing individuals who have been injured in car accidents for over 30 years. What makes me unique and different from most other personal injury attorneys is I've done it from the other side. I have represented large corporations, large property owners, municipalities, and insurance companies in defending these types of cases. So I know how they work, and I know how they think, and I know what it takes to get a case resolved. Now, in this video, I'm going to walk you through your car accident claim so you know what to expect. Once we are engaged by you, the first thing we do is send a letter of representation to the individual that is responsible for causing your accident and or their insurance company to put them on notice of our representation of your potential claim. In a car accident claim, we also send out an application for no-fault benefits so you can get your medical treatment paid for. New York is a no-fault state, which means your insurance company will pay for your benefits regardless of who is at fault for the accident. Other vehicles insurance company does not pay for your medical treatment. The other vehicle's insurance company will pay for a third-party claim, which means if you are injured, they will pay for your injuries. However, your insurance company pays for your no-fault benefits. No-fault benefits include medical treatment, lost wages. They may pay for household help if you need it. They will pay for your travel to and from the doctor's office while you're getting your treatment. And the most important thing you must know about your no-fault benefits is that the application for benefits must be filed within 30 days from the date of the accident. And when you go for medical treatment, it is crucial that the medical providers bill the treatment to the no-fault carrier. You can go to various specialties. You can go to an orthopedist, you can go to a neurologist, you can go for pain management. Whatever it is that the doctors think you need, you can go to each specialty. And you can continue getting treatment until the no-fault carrier cuts off your benefits. And in order to do this, they will send you to a doctor that they hire to examine you. So if you're going to an orthopedist, they'll send you to an orthopedist. A neurologist, they'll send you to a neurologist. If you're going to all different specialties, they have to send you to an examination with each specialty before they cut off the benefits for that particular specialty. It is very possible that no fault will cut off your benefits from one specialty, but not another. So it's important that you continue to get your treatment if you are injured from whatever specialty no fault is paying for. What happens when no fault cuts off your benefits and you still need treatment is a whole other issue. There are many ways in which you can still get your treatment and get your treatment paid for. One is you can put it through your own private health insurance. Another is that some physicians will treat you on a lien and they will continue to treat you and take the cost of the medical expenses at the end of the case when the case is resolved, and then they will get paid. If no fault wrongfully cuts you off, there is an arbitration process. We usually wait until the end of the case before going to arbitration for no fault benefits because an adverse finding in that proceeding can hurt the main personal injury proceeding. So the no fault claim is handled different and separately from your bodily injury claim. When we send out a letter of representation on a bodily injury claim, it's usually with very basic information. At this point, we know there was an accident. We believe it was somebody else's fault. There was an injury. The extent we do not yet know, but we want to send out the letter of representation as soon as possible so the adverse party knows you are being represented and not to contact you. They should be contacting us. If they contact you, do not speak to them. Give them our information so we can deal with them. In some situations, we will start a lawsuit immediately. However, in most situations, we will spend the next 30 to 90 days gathering information information. We will gather information about the accident. We'll take pictures of the accident location if we don't already have them. We will make sure we get medical documentation to confirm what injuries you have sustained. If there are witnesses, we will attempt to contact the witnesses. So we spend this time learning more about your case. We'll learn more about the extent of your injuries, so we will be in a better position to evaluate your case when the time comes. In every lawsuit, there are 3 factors that are taken into consideration in evaluating cases. 1 is liability. Who is at fault? 2 is damages. What are the injuries that were caused by the person's neglect? And 3 is the ability to pay. That's usually insurance coverage or a deep pocket that can pay for the injuries caused by the neglect. In New York State, in order to recover for damages in a motor vehicle accident, an individual must sustain a serious injury as defined under the New York State insurance law. A serious injury is defined as death, loss of a limb, loss of a fetus, significant disfigurement, a fracture, or a permanent injury, a significant limitation of use of a body function or system, or a medically determined injury that impairs an individual's usual and customary daily activities for 90 out of 180 days immediately following the accident. This means a doctor has to say you are unable to do your normal activities of daily living for at least 3 months or 3 months out of the next 6 months following the accident. If you're in a car accident and you decide, hey, you know what, I'm not feeling well, I'm not going to go to work for the next 3 months, but a doctor doesn't say your activities are limited, that doesn't count. When evaluating injuries, we take into consideration the injuries incurred and sustained from the date of the accident to the present time, and we take into consideration how these injuries are going to affect you in the future over your life expectancy. For simplicity purposes, say a person's life expectancy is 80 years. So if you're 30 years old, we can make a claim for future damages and future pain and suffering over the next 50 years of your life. Third factor is the ability to pay. That's usually insurance coverage. In some instances, there is no insurance coverage and the defendant will be self-insured. And that means that they could be a deep pocket and has almost unlimited funds to pay for the damages. In New York State, the minimum amount of coverage any vehicle is required to have while operating in the state is $25,000. Some vehicles have more. However, we get a lot of cases where the minimum coverage is that's all that is available. So it's important for attorneys to know how to look for additional coverage, because if you're involved in an accident, the injuries exceed the coverage that's available from the adverse vehicle, we want to make sure that that is all the coverage that is available before resolving the case. Let me tell you a story about a woman who was struck by a car, and the car only had $250,000 in insurance coverage. They tendered the coverage, but before settling the case, we determined that there was another $500,000 in excess coverage that was available. So we did not settle the case. We started the lawsuit, and eventually we got an extra $250,000 from the excess coverage, so we were able to settle the whole case for $500,000. I would say in most situations, we will know the extent of the liability and the available insurance coverage within 90 days. The more difficult element to assess is the extent of the injuries, because it's usually an ongoing process, especially if the injuries are going to be permanent and cause you long-term pain and suffering. In most situations, a good doctor will treat your injuries conservatively. It means they'll send you for physical therapy, pain management, and they'll get MRIs to assess the extent of the injuries and the damage. We'll attempt to avoid more invasive procedures such as injections or even surgery. If the conservative treatment isn't working, then invasive procedures may be considered down the road. But no matter what your injuries are, we need the medical documentation in order to prove the claim. Pain is not enough. You saying that you're in pain is not enough information for us to be able to prove a case to either the insurance company or ultimately a jury if the case goes to trial. So if you are injured and you are in pain and you do not go for medical treatment, you are limiting your recovery. I hear from clients all the time, I'm still in pain, but the treatment isn't helping. I don't have time to go for the treatment. I go for the treatment, it helps for a day, and then I'm back to being in pain. It is important that this information be documented and that we have medical documentation to show you are still in pain. And no matter what is being done, it's not helping, especially if we're going to make a claim for future pain and suffering. and future damages and future medical expenses. This is so crucial because you cannot treat with a doctor for 6 months following an accident and the case comes up for trial 3, 4, 5 years later and you haven't seen the doctor. That doctor does not have the ability to testify that your injuries are permanent and does not have the ability to testify how these injuries are going to affect you into the future. However, in order to begin settlement negotiations, we need the insurance company, the insurance adjuster, or the claims adjuster, or the risk manager to evaluate your case. Sometimes they do this within 2 weeks after getting all the medical records. Sometimes it will take them several months. Regardless of how long it takes them, we cannot negotiate until they have evaluated the case and they are ready to negotiate. Once we have an idea of the extent of your injury, the liability situation, and the available insurance coverage, we can begin to evaluate the case. We assemble your records, investigation reports, photographs, and whatever other information we think may be helpful to the insurance company to evaluate the case. However, we cannot begin to negotiate until the insurance company has completed their evaluation. Sometimes this is very quick turnaround. It could be within 2 weeks. Sometimes it takes the insurance adjuster a couple of months to complete their evaluation. Sometimes we send it to the insurance adjuster and the insurance adjuster will change, which takes even longer. But regardless, we cannot negotiate with ourselves. We need the insurance company or the risk manager on the other side to want to negotiate as well and would like to know where they stand before proceeding with a lawsuit. Once the insurance company has completed their evaluation, we can begin to negotiate. But in order to be successful, we need to properly assess your case. There are some attorneys out there that will demand the policy limits on everything. They will make very high, unrealistic demands, which doesn't serve anybody's purpose. The insurance company will never resolve your case. The insurance company knows who these attorneys are and that they're just bluffing and will spend years in litigation because they've made unrealistic demands that aren't anywhere near close to the value of the case. And the longer the case proceeds without an individual getting medical treatment, the worse the case gets. As a defense attorney, I've litigated cases where the clients haven't received treatment in 10 years, believe it or not. And those cases have very, very little value. And it always boggles my mind as to why these attorneys wouldn't settle the cases years ago for realistic numbers. So let me tell you about 2 cases that I currently have. Liability isn't an issue on either one. One involves a woman who sustained soft tissue injuries to her neck and back. Nothing was broken. She has not had surgery. She hasn't had injections. She treated for about 6 months following the accident and then intermittently thereafter. She feels relatively better since the accident. She still has some issues, but she's indicated she is not going back to the doctor. That vehicle has $100,000 in coverage. So we are in the process of resolving that particular claim because there is no real upside. If she's not going to go back to the doctor, we know there is a limit of $100,000 of coverage, so the likelihood of getting any more than that is very unrealistic. And quite frankly, if she only treated for 6 months, we don't have the medical documentation to support anything more than that, the case is not worth close to $100,000. So we are in the process of negotiating and we're going to resolve that case. The second case is different. The second case involves an individual where there is $300,000 of insurance coverage available. He's been out of work since the accident, which is about a year. He's had 6 injections to his spine, and the insurance company, although they've made attempts to resolve the case, have not made a 6-figure offer at this point. So a complaint has been drafted and a complaint is going to be filed, and we will be litigating that case. Now, that doesn't mean that the case can't resolve once we file a lawsuit, because once we file a lawsuit, the insurance company may get more realistic and say, hey, we don't want to take the risk because they have a big risk. This individual is about 30 years old, so we're going to make a claim for future pain and suffering over the next 50 years of his life. There is only $300,000 of insurance coverage available. So even if a jury were to give him, say, $10,000 over the next 50 years of his life, that's $500,000, which is in excess of the insurance coverage. So the insurance company is going to have a problem. They're making the arguments that, well, there's nothing broken, that there are only soft tissue injuries, and probably didn't need to be out of work for a year. They're going to lose that argument and they will pay more. As you can see from the 2 examples I just mentioned, there comes a point where a decision has to be made. Are we going to resolve the case or are we going to litigate the case? That decision is up to you, the client. There are other cases we have where we believe there is a big upside, where there is enough insurance coverage and the client has injuries that they can be compensated over for the next several years of their life, but they refuse to go to the doctor. They say they don't want to do it. They want to settle the case now, and they don't want to be involved in any more litigation. And we will honor those requests, and we'll get the client as much money as we can. And if the client is happy, it's their call. Now, in some situations, there may be a disagreement as to the firm and the client as to the valuation of the case. In a situation like that, where the client is unrealistic, or we think the client is being unrealistic about their expectations, we'll give the client the opportunity to go find another law firm who will be more in alignment with their valuation of the case. So now when we reach decision time and we're deciding, do we settle or we litigate, there are two other potential options available. One is mediation, the other is arbitration. Mediation is a voluntary process where the insurance company and us will agree on a third party to mediate the case and attempt to resolve it. They cannot force anybody to settle the case. Mediation is not binding, but they will get us in a room and they will make attempts to get the parties closer together and ultimately to resolve the case. This is good because if successful, it will avoid years of litigation. And sometimes the insurance adjusters need to have a third independent party put a valuation on a case to cover their butts. It's also beneficial for us and for the clients to hear from an independent person what they think of the case and what the potential defenses are and reasons why the case should be resolved. Again, it's not binding. The only downside is it takes some time and there is a cost to doing it, which ultimately will come out of the client's recovery. However, we have been very successful in attending mediations and resolving cases. And if you want more information about the mediation process, check out my video on mediations. And arbitration is a binding process where the insurance company and you will agree to have an arbitrator decide the case as opposed to a jury. The benefits to arbitration are that the case will get resolved a lot quicker. Benefits of arbitration are time. Usually an arbitration will be resolved within 6 months to a year, whereas litigation can take 3 to 5 years. It can also be less expensive because in most cases we don't need to hire an expert to come in and testify. We can use their records or their reports. Okay, this is also a benefit and a disadvantage. There are no appeals. So whatever the arbitrator decides is binding. And if you don't like the decision, you can't appeal it. But if the insurance company doesn't like the decision, they can't appeal it either. But there is finality in a much shorter period of time than litigating the case. There are two concerns about each party in a lawsuit. The insurance company never wants to get hit for over their policy limits. The individual wants to make sure that they get money for their pain and suffering and their injuries. So in a lot of situations, we will agree to what's called a high-low arbitration, which means you are guaranteed a minimum amount regardless of the outcome, and the damages are capped usually at the policy limits, and sometimes it's a less amount for the insurance company. It is essentially a win-win because you're guaranteed to walk away with something, and the insurance company is guaranteed not to pay over a certain amount. There have been situations where a case is ready for trial and an individual needs to go for surgery. So we can't try the case under those circumstances, and we need to open up what's called discovery and allow the insurance company and the defendants to get additional medical records. They may be entitled to another examination of you, and they may be entitled to question you again. Those are just some of the many factors that will determine how long your case will take. In the first year or two, we are involved in a process known as discovery, where we will be assigned a judge to monitor the case. We will exchange information with each other, and that process usually will take 1.5 years to 2 years. When we are done with discovery, we will place the case on the trial calendar. In most counties, you can wait for 1.5 years to 2 years for the case to come up for trial after discovery is complete. If you want to know more about what to expect after a lawsuit is filed, watch my video on the lawsuit process. If you've been injured in a car accident, we can help. Ring Rizzuto at 855-RIZZUTO. We have represented individuals throughout all 5 boroughs in New York City, all over Long Island, in Westchester, and beyond throughout New York State. If you found this information helpful, subscribe, follow, and I'll see you next time.